Hi, everybody. We have reached the very last chapter of the course. Last chapter in abnormal psychology, legal and ethical issues. So this is a nice chapter, I think, to wrap things up. You may have taken other more extensive courses on this topic. So I know criminal justice offers a course or two. Dr. Stanbush offers an excellent psych and law course, which isn't just about abnormal psych, but about many things which you could take. So since this really isn't a complete focus of the course, I'm just going to do just a quick lecture on it, just sharing a couple notable things that are most important to abnormal psychology, but it's interesting to people. So I'm going to make sure that we do cover it. On this page are a few notable examples of people who have tried, some successfully, the insanity defense, which is obviously most applicable to abnormal psych. So in the upper left-hand corner, some of these people, you may not know who it is. That's John Lee Malveaux. You may remember, you won't remember, you may remember hearing about in the early 2000s, he and an older man that he had just kind of befriended. These were the Washington, D.C. snipers. Remember hearing about that? The people that would just hide in random places in the D.C. area and then just shoot people getting gas at gas stations. And they finally caught them. And this guy was 16 or 17, I think, at the time. And so the older man that he was doing this with was executed. Well, because Malveaux was a minor, he was committed to a life sentence without parole. That has since been switched to a life sentence with the possibility of parole. So he may get out of prison at some point. So going clockwise, this is John Wayne Gacy, one of the most notorious serial killers of the 1970s. And one of the scary things about him, in addition to this picture, is that he was somebody who was trusted by adults, and he tended to prey on children. So he was a clown for children's parties. That's one of the things he did to make a little bit of extra money. This was in the 1970s, and he was executed in the early 1990s. He tried to claim insanity and did not get away with it. Of course, Jeffrey Dahmer, we talked about in the early 90s. He also tried to plead insanity, but there was all kinds of evidence that he knew what he was doing was wrong. He knew what the laws were, so he did not meet the criteria for insanity. And he, of course, died after just a couple years in prison. This is John Hinckley, who in the 1980s tried to assassinate Ronald Reagan. And he was the guy who was found not guilty by reason of insanity and had a diagnosis of schizophrenia. And he had some paranoia going on. And also, one of the big things about him is that he was trying to get the attention of the actress Jodie Foster, and so wanted to do this grand scale event that would catch her attention. He was held in St. Elizabeth's. It's basically a forensic psych facility for a long time. I think I mentioned this to you, and he was just actually recently released. He's going to be tailed by the Secret Service the rest of his life, but he was finally released after increasing amounts of freedom and less supervision over the years. So even though we don't cure schizophrenia, obviously they have deemed that he is no longer a threat to society. And then this guy here, you might not recognize him. This is Kenneth Bianchi. He was notorious in the 1970s for being the hillside strangler. He preyed on young college women and then would kill them and leave their bodies on one of the hillsides in LA. That's how he got that. He got that name. This was in the 70s, and the interesting thing about him is he tried to claim not guilty by reason of insanity for multiple personality disorder. So he tried to make the claim that one of his other personalities was doing the killings. But they caught him through a very clever way. He claimed that he, the original personality, Kenneth, there was another personality that was doing the killings. And so in cross-examination, the prosecution and one of the attorneys, or it was a psychologist, I'm not sure which, said to him while he was on the stand, okay, now we know that research shows that when someone has multiple personality, there's always more than one. There's always at least two extra personalities, and we're wondering what role does this third personality play in this? Well, that's not true. It was a trap. There isn't always a third personality, but lo and behold, there on the stand, this third personality came out. So basically they got him. He was making up the whole thing. So he did not get away with not guilty by reason of insanity, and he is serving life in prison. I want to say in New York, and he is still in prison. I checked up on what was happening with him. So the insanity plea is not the only issue that's important for abnormal psychology. Let me just list a few here that would be critical, and we're not going to talk about them all. Duty to warn, we are going to talk about that. We're going to start with that. Assessing competency to stand trial. So somebody has committed a crime, there's going to be a trial, but there's a question as to whether the person really understands what they did was wrong and is able to assist in their own defense. So I've done a couple of these evaluations in my career, and they're interesting because along with insanity, we're not going to put somebody on trial who is incompetent, either due to a mental illness or a cognitive disability, something like that. I'm going to ask you to read about this in your textbook. The insanity defense we will be talking about, and then civil commitment I'm also asking you to read about in your textbook. And this is the process we go through to have a person admitted to a psychiatric facility for a period of time against their wishes. So if somebody is dangerous to themselves or dangerous to somebody else but doesn't want to go or doesn't think they need to go, there is a judicial process to go through for admitting somebody, essentially against their will. So that I'm also going to have you read about. So we are essentially going to talk about two issues, dangerousness and duty to warn, and then the insanity defense. So we'll start off with the dangerousness and the duty to warn here. This is one of the issues that most people tend to be aware of. Now we know that when you see somebody in counseling, it's confidential between the client and the counselor, except with certain exceptions. So this addresses the question, how responsible are therapists for the client's well-being and then the public at large? So if you're counseling somebody, of course you're responsible for their well-being, but are you responsible for protecting the public to some extent? And the answer to that is yes. So if your client is threatening somebody while they're talking to you, what do you do about that? Now, the one case I want to talk to that leads to what the current standards are is the 1969 Tarasoff case. And I know that sounds, oh, that's so old, that's boring. It's absolutely not. Let me give you just a quick rundown of what happened here. So in 1969, there was a young college student, that's her picture, named Tatiana Tarasoff, who was attending the University of California at Berkeley. And she became involved with a young international student, I believe he was from India, and they struck up a friendship and just kind of, I guess they casually dated. In her mind, it was clear it wasn't serious, but he really developed strong feelings for her, let her know, and she let him know very clearly that wasn't what she was interested in. She just wanted to be friends. He struggled with that. He tried, now we would probably say he was somewhat stalking her, but he tried really hard to convince her and was very upset about it, and then just really started having some emotional difficulties with it. Summer came and she did some kind of exchange program, left the country, and he stayed at the university. And during that summer, he really started having some difficulties, began seeing one of the psychologists at the counseling center there at Berkeley. And in those sessions, he reported that he had thoughts of killing her because it was the whole, if I can't have her, nobody else can. So the campus psychologist alerted the police, the campus police. The campus police came, they interviewed him. I think they committed him to a hospital for maybe a day. It was just a short period of time. They evaluated him and determined that there was really no risk, and then they let him go. Well, she returned to campus at the end of summer, I think it was. He started making some really kind of scary threats and comments toward her. I believe the campus police were called a couple of times, and eventually he killed her, and they never committed him or never really did anything more. So after that, her parents, of course, sued everybody when they found out what had happened. They especially sued the campus police for not intervening more. They sued the campus psychologist for not doing more. And the case went back and forth in the courts and eventually went to the Supreme Court for a long time, because the opinion was that the campus psychologist and the police had a duty to warn her. In all of this, nobody told her or her parents that he was threatening her in that way. And so her parents made the claim that they should have, because they would have taken more extreme steps to protect her, of course. So after going back and through the courts for years, it's kind of come down to is that psychologists have a duty to take reasonable steps to protect an identified potential victim. So if my client tells me that they are going to harm their spouse or their ex or their brother or somebody, I am indebted to take reasonable steps to protect that person. And that would probably involve calling the police. Really, they would be the ones to call. So I have a duty to take care of my client, but I also have a duty to protect potential identified victims. The problem comes if you have a client who says something like, I'm angry at the world, I'm just going to go on a shooting spree or something like that. Well, there are still things that you can do, but there's not really an intended identified victim in a situation like that. And these rulings really came into play, especially in the 1980s, really during the thick of the AIDS epidemic, when counselors would be seeing clients who knew that they were HIV positive, yet were still having sexual partners and they weren't disclosing that to. Well, that's, a lethal weapon essentially, but the partners aren't identified, so it's hard to know. So this is one of the most complex and difficult issues that counselors come across. And in my mind, the bottom line is, if you're seeing a client and you have a question as to whether you have a duty to protect someone, every facility that you work for has attorneys. So you had best call one of those attorneys. Definitely talk to a supervisor, but it'll probably merit a call to an attorney to find out what to do also. Unless, of course, you think it's an immediate threat, and then law enforcement has to be contacted. Okay, moving on here to the insanity defense. This is one of the best known and the most controversial laws that we have. Here's a little video clip that I know we're at the end of the semester and time is an issue, but if you have a minute, it's just a couple of minutes, and it's, I think, a helpful way to explain why some of the problems with the insanity defense and why it's hard to prove insanity, why it's not used very much. So a couple things to know. The first thing is that insanity is not a mental health term. It's not a term we use in mental health or medicine. It is a legal term based on state law, not the DSM. So a person is judged insane based on state laws, not a diagnosis. A diagnosis can help make that determination, but it's not based on it. So under some laws, a person could be hallucinating, delusional, have really severe schizophrenia, but if they knew the difference between right and wrong and knew what they were doing was wrong, they could still be judged as sane. So our lay definition of sane is not necessarily the same as the legal definition of sane. And because of its notoriety, we assume it's a common event because we hear about it on the news. It's a very uncommon event. It is used in less than 1% of all criminal cases, and it's successful only 25% of those times. So it's teeny tiny, used less than 1% of all criminal cases, and the times it is used, it's not typically successful, only about 25% or so. So really it's rare. Most of the time, people who successfully plead not guilty by reason of insanity have schizophrenia. That's the most typical situation. It is usually used by people who are lower income, accused of a nonviolent or a marginally violent crime. Lots of times white males with marginally violent crimes when that is the case. Now, I think people sometimes think that pleading insanity is a good deal because essentially you're saying they're basically saying that the person is innocent. It's basically a plea of innocence. I'm innocent because of this illness or because of this condition. But it's not a sweet deal to plead not guilty by reason of insanity. It's not that you get off scot-free. So let's talk about that here. If you plead it successfully, the outcome is usually commitment to a state hospital's forensic unit, like I mentioned the St. Elizabeth's in the DC area for John Hinckley. So commitment to a state hospital's forensic unit for an indeterminate period of time. So you're not given a sentence of, 10 years or 20 years. It's okay, we're going to commit you to this. And sometimes it's longer than a prison sentence they would have served, because they have to judge that you are no longer a danger to people. And if a person really does have a mental illness, that's really hard to make that claim. So it's not the greatest deal, but the reason we have it, and really the crux of the argument, is it fair to punish someone for a crime in which they didn't have any control over their actions? And most people would say no. If you are really sick and you couldn't control yourself, then you shouldn't be punished for it. That's kind of the bottom line with the insanity defense. After the Hinckley trial, which I mentioned, there was really a lot of fallout to tighten the laws. There was a lot of controversy around that trial, which there's lots of books written about it if you're ever interested. Okay, so let's talk about how we determine sanity or insanity, or how the legal system determines sanity or insanity. So generally there are 4 standards that could be used. Each state gets to determine its own standard. So the first one, and the most popular one, is the M'Naughton standard, or some version of the M'Naughton standard. And this comes from Old English law, 1700s, 1800s, I think, where a guy tried to kill the prime minister, the assistant to the prime minister, and he was apparently hearing voices that was telling him to do that. So it's really been around a long time. The M'Naughton standard asks, did the person know what they were doing, or did they know that it was wrong? So did the individual know what they were doing, or know it was wrong? So if they realized that they were killing someone, but they did not realize that it was wrong, so they have to meet one of these. They would meet the qualifications for the M'Naughton standard, or if they just didn't know what they were doing because they had strong delusions, something like that. It's very popular. Over half the states use it. Most states and federal courts use some version of the M'Naughton standard. Ohio uses the M'Naughton standard. One of the difficulties with it, though, is that it has been accused of having somewhat of a narrow view. For example, what if I knew what I was doing was wrong? I knew what I was doing, I knew it was wrong, but I could not control myself. Maybe blinding rage, or, a trauma, something like that. Well, you would be found guilty under the M'Naughton standard. You wouldn't be able to use that. So some states have put clauses or conditions on that. A second standard is the irresistible impulse standard. And this one looks at a person's inability to control their impulses. And a lot of states have kind of a version of that tacked on to the M'Naughton rule. So are you able to control your impulses? And that's the example I just gave you. You knew that what you were doing was wrong, but you absolutely could not control yourself. And so how do you judge that in a person? And the bottom line of all these insanity pleas is that you have to figure out whether the person really knew what they were doing or knew it was wrong at the time of the crime. And of course, generally no one's there unless you have witnesses, and even then it's hard to prove because you can't get into the head of the person. But that's why these are so difficult. So at the time of the crime, were they unable to control their impulses? And they use something called the elbow rule to kind of gauge that. It's very subjective, but the idea is if a police officer had been standing at the person's elbow, would they still have committed the crime? And if the answer is yes, they were so enraged or so out of control that they would have, then okay, that was probably an irresistible impulse. But if the answer seems to be no, then they probably could have controlled their impulses. And there are examples. I mean, we've seen examples of people, for example, who have killed someone who has hurt them or abused them. They knew what they were doing was wrong, but in a rage or out of fear, something along those lines. So this can be used. So it's meant to account for overwhelming emotions that people have, or mental illness. So if a person with schizophrenia might know what they're doing is wrong, but be unable to control themselves. They may have delusions or hallucinations that are so strong that they feel they have to obey them. So the irresistible impulse can be listed many times as a provision. Okay, some of the provisions a little bit less likely to be used are the Durham standard. And this one asks, was the crime a product of a mental disorder? In other words, you have to be able to prove beyond a reasonable doubt that a person had the disorder at the time of the crime. So, even people who have schizophrenia have moments of clarity many times. So, were they under the influence of a delusion at the time of the crime? So, it's really a very broad definition, which makes it difficult. But the problem is, what's a mental disorder? I mean, we've already seen that caffeine use disorder is listed in the DSM. So, if somebody has, a bunch of jolts or energy drinks and then goes and commits a crime, can they say they had caffeine intoxication? And of course, that's a ridiculous example, but what's less ridiculous is something like alcoholism. A person can say, I have alcoholism, it's a disease. I am a victim of this disease, and so therefore I committed the crime as a result of that disease, and I do not need to be sentenced. One last standard here that's used is the ALI ruling, or the American Law Institute ruling. And this one looks at a couple different conditions. It's really kind of a combination of the irresistible impulse and the Monotone standard. So this one says a person is not guilty by reason of insanity, not responsible, if, as a result of mental disease, A, they cannot appreciate the criminality of their act, so they don't understand that it's wrong, or B, they lack the ability to conform their behavior to the requirements of the law. So this is sometimes called the appreciate and conform rule. So one of these has to be the situation. Either they don't know whether what they're doing is wrong, or they really can't control themselves. So it combines Monotone and the irresistible impulse rule. Now, none of these insanity rulings apply, DNA does not apply, to antisocial personality disorder. And there are a few others, but antisocial is one of the main ones that comes up in insanity rulings. Because people with antisocial personality disorder have an ability to charm and fool the public, as we've seen. So it would be very easy for them to say, well, the laws don't apply to me, so I didn't understand why it was wrong. So none of these apply to antisocial personality disorder. And speaking of that, I don't know how many of you last year, right about this time, Netflix released that Ted Bundy documentary. It was really interesting. If you haven't seen it, and if you've got the stomach for that kind of thing, we talked about it in this class last year. And he was, talk about sociopathy. He was the poster child. But this documentary goes through all the killings he did, and his ability to kind of charm and fool everybody. And he'll smile right into the camera, and was a good-looking guy for the most part, and would say, hey, I am innocent, I haven't done this. So they went through all that. But one of the interesting things that happened as a result of it, and maybe you remembered this, is that suddenly there were all these Ted Bundy fan clubs that started popping up, and how good looking and desirable he was. And so it actually caused Netflix to release this statement. I've seen a lot of talk about Ted Bundy's alleged hotness and would like to gently remind everyone there are literally thousands of hot men on the Netflix service, almost all of whom are not convicted serial murderers. So basically it was this glorifying this man, and he was a cold-hearted killer. There's no way around it. He was executed a number of years ago, and was just awful. So anyway, that video, if you've maybe got time this summer, take a look at that, and it just has some interesting information about him, about psychopathy, and certainly the criminal justice system. Okay, to finish up here, let's talk about a few potential problems with the insanity defense that we have. It is not a perfect system, and one of the reasons it's not used very often is because it's not typically successful. There's just a lot of holes in the theory. So first of all, we are asking an unqualified jury to make an impression about sanity or insanity. So it's like asking 12 people with no training in medicine to diagnose stomach pain. You've got people on a jury who are, everyday people, and we're presenting them with probably complicated psychological evidence, terminology. It's almost like you all have probably heard about the OJ trial years ago, and they presented all this horrific DNA evidence to the jury who didn't understand any of it. So you might think, okay, well, maybe we could fill a jury with people who had knowledge in psychology, but then you're going to have a different kind of bias. So asking a jury of everyday people is probably a big problem. It's also, as I've mentioned this, it is very difficult to determine mental status at the time of the crime. Nobody was there, nobody saw, probably nobody knew what was going on in the person's head. So what they have to do is make subjective judgments, which have all kinds of problems. And then the third one, this is more on a societal level. Many people argue that if a person is declared not guilty by reason of insanity, where's the retribution to society? I mean, you still did it. You still hurt the person or killed the person. So are guilty people going free? Are dangerous people not going punished? So then we get back to, but are you at fault if you have a mental illness, etc. So many people feel that they just don't pay their debt to society. So we have some alternatives. One of the alternatives that isn't used very often, but I see it once in a while, is the GBMI, the guilty but mentally ill verdict. Now in this one, there are two separate trials, so it's more costly to everybody involved. First of all, there's a trial to determine sanity or insanity. And again, the jury or the judge is the one that makes this up with assistance from mental health professionals. And of course, you're going to have mental health professionals on both sides, the defense and the prosecution. And the defense will try to get psychologists and professionals to tell you why they think the person is insane. And then the prosecution will try and find professionals to examine the person to declare that they are not insane. So anyway, there's one trial for this one. And then there's a trial on guilt or no guilt, which most of the time, if a person's on trial, they are guilty. But then the sentence for this, so the person is sentenced to, first of all, psychological treatment and then jail for the remaining amount of time. So it's kind of a combination of prison and treatment. There is mental health treatment available in the prison system, but it's sparse, it's chaotic. There just aren't enough people to provide those kinds of services. And for a person who is seriously mentally ill, this probably isn't going to do the trick. So usually they're sentenced to like a prison forensic mental health system, and then given prison if that seems appropriate. But there's still contradictions, because if the person wasn't responsible because they were sick, why should they pay? But guilt is guilt. You still did it, and society wants to see retribution. So the bottom line is there's no great answer to this one. So what are some potential reforms? They're always talking about reforms to the system, and of course things are very slow to develop, but here are a couple of possibilities. One of the best ones is, how about give better treatment in prisons? Again, that's a pie in the sky kind of thing, because we need the professionals to provide it, but that might be helpful. This arrow is supposed to be down here. Less reliance on subjective testimony. So the subjective testimony is coming from the mental health professionals, because again, there's no blood test to determine whether somebody has schizophrenia. Nobody was there to judge the person's mental state at the time. So perhaps less rely on that, but what else are you going to do? Pick a more qualified jury. So you could pick people with mental health training or medical training, but then you're still going to have dissent among them. And then perhaps have a trial by more than one judge or jury, because that may help even out any kind of disagreement that they may have. But again, then your expenses are going to mount, and people really have a hard time with that, and people are in jail for a long time. So there unfortunately aren't any great answers to this. I've got this very silly last cartoon. Mr. Evans, it's a speeding ticket. You cannot plead insanity for this. So yes. Okay, well that's all we're going to take the time to talk about in this particular lecture. So please make sure you go to your textbook and read up on some of the issues provided around civil commitment and also patient rights.